Kyle McNulty, and you're listening to Secure Ventures, the show that follows cutting-edge founders in the cybersecurity space to understand their plights, glories, and revolutionary products. With me in this episode is Andy Lunsford. Andy is CEO and co-founder of BreachRx, which provides incident response management tooling to help organizations respond effectively, consistently, and in accordance with legal requirements. Andy has a JD, an MBA, and a philosophy degree, which combine for a unique skill set. He worked in data breach litigation early in his career, and before starting BreachRx, he was a director for a government consulting group specializing in technology litigation. BreachRx ties together his experience across his career as he's uniquely knowledgeable about the legal complications that arise when managing cyber incidents. In the episode, we jump from the evolution of data privacy to the importance of dedicated communication channels for breach response to the personal liability of executives in cyber incidents. This episode is brought to you by VulnCheck. VulnCheck helps teams defend against weaponized exploits by delivering the most comprehensive vulnerability and exploit intelligence in the market today. VulnCheck gives enterprise and federal teams better, faster data so they can autonomously prevent exploits and reduce risk and outpace adversaries. So what's different about VulnCheck? The company delivers its solutions to teams in machine-readable and consumable formats for a truly autonomous approach to vulnerability prioritization and exploit mitigation. VulnCheck has close to 300 million unique data points, which is 5 times the exploits of ExploitDB, and 200 plus CVEs packaged into complete detection artifacts for proactive teams. VulnCheck provides a full suite of solutions to enable teams with rapid adoption of VulnCheck data, including its community tier of offerings and its enterprise-class solutions, exploit and vulnerability intelligence, and initial access intelligence. With VulnCheck, teams can proactively defend against remote execution events, enrich every data source, and continuously outpace adversaries. If you're interested in learning more about VulnCheck and checking out the free community edition where you can play with their database of known exploited vulnerabilities, please click the link in the show description so they know you came from the podcast. Andy, thanks for coming on the show.
Thanks for having me, Kyle. It's great to be here.
Take me back to the beginning of your career a little bit. You spent I think about a year at Walmart in a compliance role, and then you shifted over to Beacon Group, which was kind of a government consulting business where you were for about 11 years. What were you actually doing during that 11-year period with Beacon Group? What did that period of your career look like?
Yeah, well, kind of stepping back even before that, I think my LinkedIn profile, I don't have everything up on there, but I actually started working in data breach litigation, privacy law, cybersecurity law over 20 years ago. I started with one of the very first privacy law firms out there. It was called Oldacre, Biden and Belair at the time. Robert Belair was an FTC attorney that was doing some of the earliest litigation that we had around data breaches with the Federal Trade Commission. So I got some really awesome early exposure to what was really around the earliest data breach laws. So California was one of the first states to have one that said you need to notify all your customers whenever you have a data breach. And what was a lot of that early litigation was around California had a law, but not all the other states had a law. But all of a sudden, if you only notified California customers, but then all these other states had customers that you didn't notify, all the AGs were coming in and saying, hey, why didn't, Mississippi customers, why didn't the Arkansas customers, why didn't they get notification too? And so there was a lot of early litigation around that. But actually my interest in this space even started before that. When I was in college, I was a philosophy major and I wrote my honors thesis on the right to privacy. It was part of what kind of drove me to go to law school, was my interest in this space where privacy, technology, cybersecurity, the law all come together. It's just such a fast moving space that's very, if you're a philosophy nerd like me, super intellectually stimulating to be thinking about all these ramifications. Like, okay, is this a right I have, or is my data something that should be out there all over the place? And we have very different views across the world. We can talk more about that. But anyway, I got started with that early on, worked for this law firm that did a lot of the earliest privacy law work out there. Now, privacy law is like the biggest, fastest growing practice at every major law firm. And at the time, it was one of the only boutique firms that did the work. So it's kind of fascinating to see that journey. But then I spent some time in Walmart's compliance office, did a lot of their early figuring out, okay, how are we going to comply with 50 different state laws when it comes to data breaches, or when it comes to a number of different things that big companies like Walmart. I should say I'm from Arkansas. I actually went to law school in Arkansas. So Walmart's headquarters was right there. And so there was good reason to go there out of school. And then I had the opportunity to build a litigation consulting firm with my brother and a few other partners in DC. That's what became Beacon Group. And we did a lot of complex commercial litigation, some on the data breach side, some on just larger damages cases, but really any kind of case that involved $10 million in damages or more, we would get hired by law firms, different government agencies like the DOJ, Department of Defense, Department of Energy in those cases. And we had a stable full of experts that could testify on different topics. So whether that was computer engineering, civil engineering, he had PhD economists on damages, et cetera. Any kind of case that involves that level of damages, you have experts write expert reports. And I won't go into all the weeds for this audience on all the strategy that goes into that, but having somebody with somebody like me that's comfortable with the technical details, but also has this legal background, was very helpful as we shape expert reports and help defend companies and defend government agencies and some of the different litigations they were in. And so that was the early start.
Yeah, it makes sense as far as being able to combine those kind of skill sets in that unique niche. I'm curious, you mentioned this very early exposure, that honors thesis that you're writing as far as the right to privacy. Data breach litigation, before data breaches were so, let's say, one, common maybe, and then two, also kind of understood by the public. Now people have much more of a kind of personal connection with their data, I would say, and feel more slighted when their data is breached and when they receive one of those announcements, the letter in the mail. What do you think in kind of each of these respective areas? A lot has improved in terms of how our systems kind of manage these different processes, whether there's different privacy protections. Apple is one good example that has kind of been a landmark company for protecting the right to privacy. And again, on the data breach side, there's so much more investment going into protecting against data breaches for all these different companies. What are some areas where you think there's been some corrosion, maybe, where 20 years ago there were actually some better practices or policies that were in place that have gotten rolled back, or maybe just not kind of upkept with the same stringency?
Yeah, well, I think that it's a really interesting question. I think that one of the issues we faced in this evolution is that when we first, as a world economy, started to embrace the internet in different ways, the earliest days, when you think about a right to privacy and the kind of information that's protected, there was a much more limited scope of information that was out there from a person-to-person basis that was across the web in different ways. And then really I would equate it with like the timing of like Facebook and social media becoming a bigger and bigger issue. All of a sudden it wasn't just like, oh, I've got this account online that I'm going to pay my bills on. It's like I'm posting activity about myself or activities being monitored about myself every day, all the time. And so you have just a different level and depth of information about individuals that was a huge boon for like advertising agency to give extremely tailored ads to specific people. And there's a very big philosophical debates between those that view tailored advertising and tailored messaging to be a good thing. Like I want the things that are most relevant to me presented to me, versus those that worry about the manipulation that goes along with having those kind of tailored messages in front of you. And we see some of the worst cases of that when people point to things like the Cambridge Analytica. I don't know what you want to label that that whole ordeal, but the series of events around it. But so there is these ways that having tailored experiences that only happen through having that level of data about people that can be really good and helpful, help you go to the right place, help you understand like, oh, these are the restaurants that I would most likely go to because it knows the kind of things I like to go to. That can seem like a good thing, versus something that some people would feel like, manipulates people into voting different ways. And that, really, I think that, so when you talk about what's eroded and what's changed, I think it's, we adopted so much of this technology right away in the U.S., especially in the U.S., without any kind of check on what's the right way to use the data or not. So there's just a lot of assumptions, and that really gets back to this sort of philosophical thing for me about the right to privacy and like how important that is to a person's identity. Versus Europe, it took a very different approach. Like they do view privacy as a fundamental right. Whereas the U.S., we started with privacy was about how do we protect people from identity theft. And so most of our early laws were very prescriptive about these are PII. These are the types of personal information we consider PII. It's mostly around if a bad actor had those specific pieces of information about you, could they go wreak havoc on your life from a personal identity perspective, and basically hurt you financially. And that was really some people might say that's more of a capitalistic approach the U.S. had, versus when you think of privacy as a fundamental right, and it's not about just this specific financial information you have, but all these things about your beliefs, your religion, and all these other fun pieces that people identify with their identity. That's a different philosophy, and so I think we're seeing that play out. And I think it's kind of interesting that some of the newer laws in the U.S. That they call comprehensive privacy laws are taking some of the concepts that Europe started with and kind of bringing them over to the U.S. And California is one of the states that is a little further ahead on that. Washington does a lot too, but CCPA, CPRA were some of the early ways we're talking about something that's personal information and they should be protected with a greater degree of protection and has different kind of consequences when it's not protected, was more about a broader, does this identify with itself? Is this sensitive to a person? Not just, will this facilitate identity theft or not if a bad actor has the information? And so I don't know if I really answered your question there, but it's a little bit more about, this is what I kind of have seen as the evolution of how we are protecting or not, but some of kind of the consequences of because we've lived in a world that allowed such a free use of information and a free taking of all that data, it's kind of hard to put that genie back in the bottle. And so we're just in a place now where everybody's data is everywhere. And so after the fact now, we're trying to put it, the policymakers are trying to say, well, we hear you. There's so many data breaches that companies need to protect this information better. And the reality is that as we see, data breaches are ubiquitous. Privacy incidents are ubiquitous. There's some things that just happen from human error. Some things that do happen from nefarious actors. But it's a reality that every business has to deal with. There's just so much information out there. And so it's really more, and I think this is where we see the industry going. It's like, what kind of hygiene do you have as a business when it comes to doing as many things as you can without it being astronomically expensive to protect that data, use it the way you've told your customers you are going to use it. And when something happens with that data that's unintended or not ideal, that you are very transparent with your customers and with regulators about what happened, how you dealt with it. Did you deal with it in a responsible way? Did you deal with it quickly? All of those things are what the regulators are looking for. Now, the way they've implemented that with laws is maybe not necessarily, you could argue, the right way to go about doing that. But that's really what's driving this desire, is to make people feel like you value their information and you're being responsible with it when you've been entrusted with it.
You make a great point. I think two key things I drew out of that. One, we think about the information that's being collected on behalf of users today is far more personal than it was 20 years ago. So whether it's location data, your exact kind of preferences, whether that's food or movies or anything else, and then your social media data is included in there as well. So again, just other personal information about you. And then number two, the kind of culture differences between the US and Europe, which we've seen in a lot of different things, like Europe leading the way with GDPR, but just kind of thinking continually about how those different cultures and the existing ecosystems for business and relating to privacy will influence further policy and action on behalf of companies as well. I feel like we'll get to incident response in a second, and we'll tie this all back into BreachRx, but I have to ask, because it's very topical. We're talking about the collection of additional personal information. Google just rolled back its decision to remove cookies just a couple days ago. How do you think this ties into everything that we're talking about? Obviously, they had kind of made this large and again, kind of landmark decision to remove what advertisers had very much relied on to capture user information. And they're saying, okay, now we're going to actually keep these cookies in place. It's too important to the overall ecosystem, going back towards that maybe capitalist nature in the states that we see today. What are your thoughts?
Yeah, I haven't, other than the headline of seeing that they are rolling that back. I haven't read into the details of whatever kind of public statement they made about it to see all the nuance. So what I'm saying here would be just my speculation on it. But I think when it was announced that they were going to remove cookies, the advertising agency or advertising world was, really aghast. Like, this is such a critical part to how we do things. There's so much of the advertising world is built up around the use of those. And the other piece is that Google's primary revenue is advertising, and the fact that they have, Google search, and a lot of people pay a lot of companies pay a lot of money to have different access to not only coming up in search rankings, but then, how you track the type of people that are doing those searches and whether they're going to your website and where they're going after the website. And that's, obviously the key thing of having that level of tracking. So I'm not entirely surprised that is the move that they made when the entire ecosystem that supports their business model is against them getting rid of it. But it's a tough battle for them when they have competitors like Apple that are really hanging their hat on, hey, we're more privacy focused versus some of the other technology companies that they're trying to do their part to say, okay, we're doing some privacy leaning things as well. I don't know if it's related to this at all. There's also, in the privacy world, amongst a lot of my chief privacy officer friends and general counsels, there's a big deal. Notice that the chief privacy officer at Google recently left, and Google has decided not to have that role anymore. And so, there's debate about the choices with that, but it's interesting coincidence of timing, at least, that person's exited, that role's not filled, and now they're saying that the cookies are coming back. Had no idea if those are related or not, but it's very interesting timing.
Yeah, it certainly sounds related at a surface level, at least. But let's tie this back together with BreachRx and your story. We've talked about privacy for a decent chunk of this. You, towards your last statement, kind of mentioned the importance of just hygiene and the expectation for companies, both from a regulator standpoint and then to some extent from a consumer standpoint as well, saying, okay, are these companies at least behaving in ways that seem like they're working to protect my data? Obviously, things will happen, people will make mistakes, but are they performing as they should and in accordance with best practices? You founded BreachRx in 2018, I believe, with a lot of this in mind in terms of just restoring the hygiene that goes into incident response preparation and incident response action. Tell me a little bit more about how this all came about.
Yeah, well, so, living in the litigation world of data breaches and feeling the long tail consequences that many of my clients experienced of going through a data breach, and data breaches, some handled well, some not handled quite so well. It really became, could see a lot of patterns as to what the differences are between results for a company that comes out, less scathed than another when it comes to how they handle a data breach. And so there's a passion for me on companies can do this better. They just need to be more proactively prepared. And unlike a lot of areas of the business that have seen automation help them do things better for many different types of business processes, incident response was not one that had seen a lot of automation. Most of the tools in this space are focused around how do we detect that a breach has happened, how do we contain the threat, eradicate a threat, restore the systems, very technical. But there's a much bigger business problem going on, that when a breach happens, it's a very complex, coordinated response process that includes not just security and legal, but communications, leadership, business units need to talk to customers. There's a whole wide different parts of the business that all have to come together in a very coordinated fashion to execute all the different workflow that has to happen. And they don't have a place to do that. They're all kind of working out of silos. They're all working in very disjointed fashion. And so there was, in my view, a real need to have a single system, a single place where you can come together to collaborate and do this work. So that was the overarching element. And then in a real particular way, from a legal and regulatory perspective, we had expanded from every U.S. state having its own data breach law, GDPR coming into effect, that said, hey, not only do you need to notify about this breach, but it needs to be in 72 hours, and penalty could be up to 4% of your revenue. And so from my view, when GDPR was coming into effect in 2018, it was passed in 2016, that was writing on the wall for the direction we were going with all these laws. So it's not just that you need to notify, but how it's going to be faster, there's going to be bigger penalties. And I even saw that there was going to be personal liability as a piece of that as well, not just the fines to the company. And it really, there's certainly a reason that companies need to take the data of their customers seriously, and they need to protect it the best they can. But it always fundamentally bothered me that if your company is the victim of a cyber attack could be a very sophisticated nation state actor or all different kinds, that you're a victim of that attack, but then you also become a victim to potential regulators and lawsuits and all these additional consequences that come to you after you've been attacked. And I give this kind of basic analogy is like, if you think about if your house got broken into and the police came and took you to jail because your house got broken into, no one would think that's fair, right? But in a way, that's kind of the direction where we've gone in the cybersecurity world, that we're going to really punish the victims, and ultimately the consumers are victims, obviously, here as well. But I felt strongly that if we can just make this process work better, if we can make it more efficient, we can help companies deal with these situations that are inevitable, help them do that in a real responsible way, then there's no need to carry these additional penalties from this situation. And so that's our mission as a company, is how do we help protect companies, protect those individuals that are at the companies, and then ultimately, which I think ultimately trickles down to the consumers themselves. The better a company, the better hygiene they have there, the better they're able to handle that, the fewer consequences you'll see for the end consumer.
What does that look like in practice? I think what you just described is a fairly broad mission in terms of how do we kind of streamline the incident response process? How do we improve the ability for these companies to kind of handle incidents, both in incidents themselves, but then again, also the fallout, like you just mentioned, from a legal standpoint? Where do you actually start with kind of providing these different capabilities? Yeah.
So our platform starts with helping our customers be proactively prepared. That's the number one piece to start. And so we have a number of modules that come in our platform that help customers do that. One is a regulations module where we've taken all the 200 plus global regulations. We've broken them down by the conditions that make any one of those regulations apply. And when they do apply, the workflow that a company is going to need to carry out. So having that as a basis, because that's a huge driver in activity, but you also have contractual obligations that you need to take into effect the same way. You have cyber insurance obligations. You have all sorts of actual control activities that need to happen within a company, communications activities. So we basically pull all those together in a way that allows us to take the details of any incident and then auto-generate a tailored action plan that's specific for that company, specific for any incident they're facing, and ultimately gives them a place to collaborate and do all that work together in one place versus all the different silos, the Slack channels, the Teams, the email, phone calls, all different disjointed ways this happens today. We pull that all together. But back to executing. So it's all about being proactively prepared so that when stuff happens, you're ready to execute. People know exactly what they need to do. They can see in real time what other people on the team are doing. so that they can actually get to the end of this process as quickly as possible and do it in a responsible way.
And so if I'm understanding this right, and maybe oversimplifying a little bit, you have kind of this expanded checklist of here's all the regulations that kind of apply to you. And so that way you're prepared for what these look like as a business. Then an actual incident happens and you say, okay, these are the specific things that apply to you in this specific incident. And therefore, here are the different actions you need to go ahead and take. And then the second piece or third piece is the communication element. So you say, okay, everyone just uses this platform. We go ahead and document all the different communications that are occurring in relation to this incident and streamline some of that communication across the different groups. Is that a fair summary of everything you just said?
It's
oversimplified.
It's a little oversimplified, but I think the key is it's a lot more than a checklist. So I think a typical incident response playbook that people think about, or an incident response plan, is a little more checklist oriented. People think about it as like, okay, my incident response plan, it's got the high level. What are the severities? What are the people that are going to be involved on the team that are going to do this work? And then we've got these playbooks for these scenarios where it's a long list of, we need to do these set of activities. This is much more sophisticated than that, and that we're helping guide the company through the process from beginning to end with the way that our workflow works. So it's dynamic. So it's really you're not getting a laundry list of a checklist of things to do. You're only getting the things that apply to your organization when they apply at the time. And so that's very different than really any other technology that's out there today that's much more checklist oriented the way you're describing. That's just like, hey, here's a long list of things you need to go through one by one to check off.
And so you're saying it's basically more of I think you already used the term, but workflow, where it's kind of giving you one step at a time based on where you are in the process.
Yeah, guided. Think of it as like a trusted guide through the process.
Sure. And I'm always curious when I hear about these kind of streamlined communication channels, like you just mentioned, right? Let's say you have an organization that's already using Microsoft Teams as their kind of default communication channel across the entire organization. What have you found in terms of willingness for these companies to go ahead and adopt your kind of new communication channel when everyone's already comfortable with Teams, everyone already has group chats with some of these different relevant people? They could go ahead and just make a new channel or group with all the people that they know are relevant. Obviously, you have the potential to do some things wrong there, exclude some people, maybe not the right information handling. But have you seen a lot of resistance where folks say, we want to use the channels that we're comfortable with, not use this new communication platform specifically for this incident where we don't get the same kind of push notifications or whatever else that looks like?
Well, we have all kinds of notification formats to like kind of solve that piece, but actually this is a really important point. And so if you do that work in Teams, if you do that in Slack, you do that over email, you have all kinds of attorney-client privilege issues around that as communications being discoverable when it comes to litigation. So this comes back to my litigation background. There's it's a subjective test as to whether something is privileged or not, different types of communications, but doing that work in a system that's a broader business system that's designed for other purposes is pretty much right off the bat going to make a lot of those communications come into evidence when it comes to any kind of court case. So to the extent that you're wanting to have truly confidential communications, which many people do when these things are going on because it's super sensitive, choosing to do that work in those channels is a problem from that perspective. But even on top of that, when you think about any kind of compromise situation, you don't know where the adversary is. They may be in your environment, these different business environments, whether that's Slack, Teams, email, and monitoring everything that you're saying back and forth. So there's a real value in having an out-of-band place to do this work, just from a pure security perspective, not to mention the privilege aspect of it. So what defaults to people doing is they're like, and this is partly, I can go probably a lot of depth on this if we want, but as lawyers, we really trained people for a long time, write nothing down, like minimize any kind of communication. Let's only pick up the phone and talk about it, because anything you put into words could be used against you in court. It all becomes, potentially additional liability for you. So it's really important that you have a place that you feel like you can do this safely. And we've seen a number of court cases where, if you did that in Teams, you did that work and emailed, all that evidence is coming in, entire servers beyond even the incident themselves, all of a sudden get looked at from an investigator's perspective, which just means they bring more and more cases on other things you did that had nothing to do with the incident.
Right.
So it's actually it's a huge value driver that people see is like, yes, I have an out-of-band place where I know I can safely have privileged communications. That's a huge additional value of having a purpose-built solution like BreachRx.
Without the full legal deep dive, what is the basic rationale for why, if you have it in this out-of-band communication channel, attorneys won't be able to look at those conversations and discover them? But if it's in something like Slack, which you're already using, they can discover them as part of an incident.
Yeah, so it's about this mix between where factual and business-oriented discussions are happening, that those are not generally protected communications. Apart from the privilege piece, you have to have a lawyer's oversight. There's is this in context of potential litigation? Is this channel for where doing this work? Is it only available to person providing the advice? That there's a number of parts of these subjective tests that courts look at when they decide whether one piece of evidence can come in or not. So not having that clean separation, and that's part of what we do in the platform, is we bifurcate the activity, because you have to, at the end of the day, you have to provide a record of what you did when and what you knew when. That you have to be able to provide that. And so when you do that work in Teams and Slack and email, it all gets intermixed. The factual information from what maybe is a sensitive thing you're asking counsel about and wanting to get advice on, or not something you want to be part of the record you generate. So if you don't have that cleanly separated, or if you do it by just trying to label something as attorney-client privilege, that's not enough. And so that's really what ends up happening when you get down to litigation at the end of the day.
Super fascinating. I mean, it's a whole kind of rabbit hole. You clearly have the legal background for understanding all of this, but I think this kind of ties into the whole point here, which is without that legal background, some of this nuance is very much lost. And certainly on myself, I mean, thinking about new considerations that I hadn't thought of before. You mentioned before this kind of personal liability piece, and I definitely wanted to dive into this a little bit further. I don't even know where to kind of tee this off exactly, but thinking about the kind of incident response planning and just overall handling, where are the cases where personal liability is actually brought in? I assume not every incident has a kind of element of personal liability to it. So when is that kind of most apparent or possible for the executives behind the scene?
So this has been really a more recently surfaced issue. The one case that most people look at first is Joe Sullivan, former CISO of Uber, who is a senior advisor to our company. He went through a case at Uber where they had, I won't go into all the facts of their case, but essentially, at the end of the day, the company decided to say, hey, he was responsible for covering up this breach and us not reporting it the way that the government suggested that they should have reported it. And so he actually got charged with a felony and unfortunately got convicted of it. More recently, we currently have a big case with SolarWinds, and Tim Brown, the CISO there, is being charged with fraud. There was a recent decision that dismissed some of the charges against him, but he's still going to be going to trial on some pieces of the actions. And it was around how did SolarWinds handle the breach that they went through. And then that opened up a broader investigation into how the security program was run and what kind of statements they were making about their security program. So there are a lot of different angles here that can bring in personal liability, but in the breach context, it's really important that you're able to show that you took the right actions at the right time and you have a record of doing that. So it's, we know something on day one. This is what we did when we responded to that. We got more information. We took additional steps. We escalated as we needed to. We followed a plan. that was sound, and that we follow that plan every time we have an incident. There's a lot of different angles that they look at, but if you're not generating a record of how you're doing that work, and you're just following this kind of, I'd call it the legacy legal approach of let's write nothing down and not have any kind of record of it, it's very easy after the fact to get thrown under the bus the way the situation has worked for some CISOs, where the company says, oh, it's all the CISO's fault. They didn't do their job and they get fired, or they should be the one to go to jail. And unfortunately, that's the stakes that have been raised. So the regulators' approach to wanting to get that level of transparency and wanting to make sure that executives and companies are handling incidents the right way, that's why they've upped the ante recently and said, hey, we're not only going to find companies, but we're going to be looking to go after and hold specific executives responsible. And it's not limited to the CISO. I mean, we've even saw in the Drizzly case where the CEO there is being held personally accountable for the security program at Drizzly for the next 10 years based on an FTC consent order. So it's quickly moving from not just the CISOs, but you've got CEOs, CFOs, anybody that's a publicly traded company that signs 10Ks. All of those execs are potentially on the hook. People are even talking about boards having responsibility for some of these issues as well. That's just the kind of next level that regulators are saying, hey, companies, you're not taking this stuff seriously enough. And so we're going to be coming after the people personally.
So with SolarWinds and Uber, it feels to me like there's a delineation. With those two, it feels like the personal liability is brought in because there was some act that was claimed as fraudulent or misleading, where I guess this goes to your point as far as transparency of communication, but ultimately you'd say these folks deliberately covered up information that they otherwise should have revealed to different parties. In the Uber case, it was the customers, and I think in the SolarWinds case, I'm not as familiar with this one, but you're saying it was the statements that they were making as far as the maturity of the cyber program. Whereas I think, again, thinking about this delineation, the next piece is, okay, companies are responsible for the statements that they make as far as their security capabilities writ large, and then are put on the hook as a result based on if there's a public filing in a 10K. So I guess part of what I'm getting at here is when it comes to personal liability in the wake of cyber events, if you are kind of honestly and accurately communicating the state of your cybersecurity program or in accordance with different regulations such as breach notifications, then is it fair to say that there's quote unquote nothing to worry about in terms of a lawsuit actually being brought against you? Obviously, your job is a whole nother thing there, but
yeah, I think if the idea is you're not personally liable because the breach happened, and I think that's maybe the misconception that gets lost in translation. Of people things like, oh, then if we have any breach at all, then the executives are going to be held personally accountable. It's really about do you handle things appropriately? Are you being transparent with how you're handling it? Are you making good decisions when you're presented with that information? And can you show that you made good decisions when you're presented with that information? And that's the challenge. And when you think about the complexity of making those decisions, it's really hard. Like if you think you have 200 plus global regulations that could apply to any given scenario, they have deadlines that are measured in hours. And so you find out in the nature of any incident is, some things on day 1, you'll know different things on day 10, you'll know different things on day 30. With that evolving level of information, and you get to any sort of tipping point, you might start having notification obligations that have a very short time clock on deciding. And so the way you avoid this liability is having a really solid, documented, a system of record for this. Like as one of our Fortune 500 customers put it, incident response records are audited like financial records. That's what the SEC is doing. And so you need to have a system that records that work and shows you acted responsibly all the steps along the way. And that's really important with this SEC law, particularly when it comes to materiality analysis. I don't know if you've had other guests talking about that, but
no.
they require you to report material incidents within 3 days of making that determination. But something might be material to you, at different stages. So it might not be material at first, and then it might become material later. And you have to have a really clean record of showing like, okay, well, we found out we had this alert on this one day. Didn't seem like much. It wasn't enough information to say it was material. Versus, okay, by the time we've done this investigation and we got more information, we figured out, okay, this is really a material to the company. You have to be able to trace that. Otherwise, the Monday morning quarterback, the hindsight view is to be like, hey, you found out about this 30 days ago, but you didn't report to then. Why didn't you meet the requirement? The SEC can bring some pain, unfortunately.
One of the interesting things that's occurred to me throughout this conversation, this last piece in particular, the concept of folks will buy products that get them promoted. So at the end of the day, a lot of acquisition decisions revolve around what is going to give you some sort of personal gain within the company, right? So what's going to get you a bigger budget? What's going to get you a bigger head count? That's going to lead to a better title, promotion, or a raise, whatever that looks like, right? And there's a super interesting and very pointed, I would say, comparison with protecting yourself from personal liability in an incident where, what is more important than from like a personal gain standpoint in financial terms, if we just look at it from that angle, then a nice raise is making sure that you don't get taken to prison, right? And so a very interesting, I would say very different sales pitch and just kind of message that you're delivering than the average cybersecurity company, and just worth pointing out.
Yeah, well, that's what I sort of mentioned this earlier, but I think our legal world, as attorneys that help defend companies, we've done a disservice for a number of years by encouraging everybody to minimize what they write down and not create records. And so taken to the extreme, you don't have records to show that you're handling something responsibly. And so it's so critical for CISOs today to make sure they have a really well-documented process that goes beginning to end and shows all the multi-stakeholders that are involved, because it is a multi-stakeholder process. It's not just the CISO and the security team that's responsible for responding to an incident. And it's really important that all of those people that have responsibility know they have responsibility and they have an opportunity to carry out those responsibilities. And having a good system in place like BreachRx to do that is the easy button, I think, for that.
So now I have to ask, just because it's so relevant right now. Last week we had the CrowdStrike incident. We're talking about incident ramifications. We've mostly been focused on personal liability. You can correct me, but I can't imagine from my initial readings that there's going to be any personal liability in this CrowdStrike case. But as we think about this whole CrowdStrike example, there's some similarities with if CrowdStrike was breached, and just the kind of ramifications in terms of outages for a lot of their customers, obviously just negative PR for the company as a whole and the capabilities of the company. If it's a breach, then you question their cyber capabilities. In this case, we're questioning their kind of DevOps pipelines and what software is actually getting pushed into production for them. What are some of the similarities that you're drawing in this case, and how are you thinking about what the ramifications for CrowdStrike are going to look like in this kind of IT outage scenario compared to as if it was a breach?
Yeah, it's an interesting, it's I guess, I hate to use the word because it kind of gets overused, unprecedented situation for us to see how it plays out. But I have a lot of sympathy for them in that you're a cybersecurity company that is heavily relied upon, has had a really stellar reputation across the industry, and there is this constant need to be one step ahead of the bad guys, and you need to be able to deploy things quickly that are going to facilitate protecting all of your customers. That being said, you need to make sure things don't break when you are deploying them, and it's a pretty standard part of it. Certainly our company, I think many to do things, any kind of upgrade you do in a sandbox environment, and you make sure you do run lots and lots of tests before you release it broadly. So I don't know enough about the details of exactly how this happened that it transpired the way it did, but obviously huge impacts across the massive customer base they do, that so many large companies that rely upon them had problems. So I think that when it comes to what downstream consequences they're going to face, it's really hard to say. Like I don't know all their particular contractual agreements with their customers. Certainly, it sounds like the CEO is being asked to come speak in Congress, so he's going to get a lot of questions about how they do things. I wouldn't be surprised if we see regulation that comes down the pipe that is in response to this, that it takes some of the same things they're doing from a cyber perspective and doing it from a development perspective. I think we regularly hear in the startup world the problems that come about from there's a mentality of, build as fast as you can and fix it later, ship it, then fix it, like is kind of what some people do, versus building it like the right way, the secure way, making sure it's good to go before it goes out. It's tough dynamic for startups with limited resources and a need to prove themselves really quickly. So I think we will probably see some motion from a regulator perspective on that. I think it's worth noting, though, that the way the SEC laws are written for cybersecurity rules, it actually includes this type of scenario. The classic cybersecurity sort of triad is protecting confidentiality, integrity, and availability. And so actually the way SEC defines a cyber incident is anything that materially had an impact from one of those ways. So this was an availability issue. So you're actually going to see, if we haven't already, a number of companies that need to file 8Ks and 10Ks around the availability loss, because it certainly impacted some businesses in material ways to be down for the period they've been. And obviously CrowdStrike is going to be, having to do a lot of disclosures itself.
Right. And like you said, so much uncertainty right now in terms of how this all plays out, but interesting to at least get your kind of initial digest on what the scenario looks like. But that's a great place to wrap up. Andy, really appreciate your time. We covered a whole host of different topics here. I personally really enjoyed it. I love diving into some of these different areas of the cybersecurity world that some of us, myself included, run into less on a day-to-day basis, but are incredibly important and relevant, especially in these scenarios. When they do unfortunately happen, if you have an incident, you want to be prepared to some extent in terms of the legal ramifications of how to manage that effectively. So thank you so much for sharing your time and telling your story.
Absolutely. Appreciate being on here, Kyle. It was great.
Thanks so much for listening to this episode. You can subscribe wherever you get your podcasts, and you can write to me at kyle@secureventures.io. I'm Kyle McNulty, and you've been listening to Secure Ventures.